Can a pro-lifer shoot an abortionist and still get a trial of the only contested issue of the case by jury?
Most lawyers do not expect Scott Roeder to get what average citizens would call a trial by jury. I'm trying to help him get one. If he gets one, there's a reasonable possibility he could be found innocent.
Dave Leach is a friend of Scott Roeder.
Roeder sits in the Sedgwick County Jail for killing late-term abortionist Dr. George Tiller May 31st while Tiller was ushering in his church.
Leach has been writing to Scott Roeder about a possible legal defense.
I think the average citizen expects that the jury will judge the contested issues of the trial and the defendant's defense. But most lawyers understand that in any abortion prevention trial, the defense is ruled inadmissible, and the defendant is ordered not to say a word to the jury about his only defense. In abortion prevention trials, the only seriously disputed issue is not what the defendant did, blocking the door, burning it down, shooting through it, but whether the abortions on the other side of the door are unthinkably harmful enough to justify stopping them. This sole trial issue is decided by the judge before the trial starts. I think most citizens would call that trial by a judge, not trial by a jury.
Won't Scott Roeder have a trial, and won't a jury be at the trial?
Yes, and the trial Scott Roeder gets will be a wonderful exercise of democracy by the standards of Iran or China. But can Americans call it a trial by jury where the judge decides all by himself that your defense is no good and won't let you tell the jury about it? Where the judge just lets the jury judge what everyone agrees to anyway? Wouldn't you call it busy work to let the jury decide facts upon which both parties already agree?
They can't do that. They won't do that. They'll let Scott Roeder present his defense to jury. Of course they will. This is America.
Ask any lawyer who knows about trials of Christians who have prevented abortion. In the past 100,000 cases, judges ordered the accused not to say a single word, literally, to the jury about their only defense. In Scott Roeder's case, the prosecutor has called 182 witnesses to present evidence which I don't expect Scott Roeder to even deny, that Scott Roeder shot a church usher during a church service. But Scott Roeder will be ordered not to explain why he shot that church usher, because of the usher's unthinkable brutality when he wasn't in church, which Scott Roeder could no longer stand by and allow to continue.
This trial isn't about what Dr. Tiller did. What Tiller did was legal. It's about what Scott Roeder did. Scott Roeder committed murder.
This trial is not about what either Scott Roeder did or what Tiller did. This trial is about what the judge is going to do. Is the judge going to allow the only defense and the only contested issue of the trial to be decided by the jury? Or is he going to decide it all by himself and just give the jury some busy work that doesn't have anything to do with the trial issues, so it will look like Scott Roeder's trial is by a jury? There's nothing more illegal than what courts have done all these years to keep abortion legal. The 1973 Supreme Court case Roe v. Wade made abortion legal, but the justices did not deny that abortion is, in fact, murder. They literally wrote that not one judge in America is smart enough to tell. Well, juries are smart enough to tell. Juries are supposed to be judges of the facts. That's what judges tell juries during every trial. But judges in 100,000 cases have kept the judges of the facts from judging the one single issue of abortion prevention cases, which is whether abortion is, in fact, so unthinkably harmful that preventing it is justified. The necessity defense is a legitimate defense in America, found in the laws of every state. It asks the jury to balance the harm Scott Roeder caused against the much greater harm which Scott Roeder prevented. If the jury finds that Scott Roeder in fact prevented far greater harm, then what Scott Roeder did was just as legal as what Tiller did. It is not yet illegal in America to stop genocide.
Leach has published his complete proposed brief at www.saltshaker.us under the headline,
Can a pro-lifer shoot an abortionist and still get a trial of the only contested issue of the case by jury?
The defense which Leach says could set Scott Roeder free is called the necessity defense.
It says you can't go to jail for causing a little harm that was necessary to prevent a great harm.
The classic example is it's okay to break down your neighbor's door and save him from a fire.
Or it may be okay to speed to the hospital if your wife is having a baby in the back.
The necessity defense compares the harm caused, in this case shooting a late-term abortionist, with the harm prevented, in this case killing thousands more babies beyond the 60,000 which George Killer publicly boasted of tilling. In most cases of abortion prevention, the dispute is whether abortion is in fact harmful enough to justify its prevention. That requires the jury to weigh evidence of when life begins, a fact question which Roe v. Wade said no judge in America is qualified to address. But juries are in a position to weigh the factual evidence. Judges call juries the judges of the facts. Yet in abortion prevention trials, judges call the fact question of whether abortion is a harm a question of law. And beginning about a century ago, judges began saying judges alone are qualified to judge the law. But this raises an important question. When the only contested issue of a trial is a dispute which the judge classifies as a question of law, does a man still have a constitutional right to trial by a jury?
We interviewed Rocky Penzenfire, the lawyer retained by late-term abortionist Larry Carwash. Larry's lawyer, Penzenfire, disputes Leach's claim that Christians are denied their rights to trial by jury.
How would you reply to the charge that 100,000 Christians have been denied their constitutional right to a trial by jury in order to keep abortion legal? Could you be more specific?
That's the thought that makes me sleep sweet at night. Forget I said that. Strike that. Here, let me strike it for you. Bang! Here's my true meaning. Ain't the pro-life trials long? Don't they call the parade of the witnesses? Don't they make the arguments and present the evidence and pay attorneys to argue with each other? What do you mean the defendant ain't allowed to defend himself before the jury? If they ask for the jury, they gets one.
Thank you, Mr. Penzenfire. We've been talking with the lawyer of the famous late-term abortionist, Larry Carwash.
Thank you, Bright Eyes. Let's get Dave Leach's reaction to Larry's lawyer, Penzenfire.
Thank you for allowing me to answer Liar's Liar Pants on Fire. It's true. Pro-life trials look like real jury trials. They are just as expensive as if they were real. The prosecutor in Scott Roeder's case has already announced he will call 182 witnesses. For what? To put on a weeks-long dog and pony show to prove what Scott Roeder doesn't even care about disputing, that Scott Roeder shot the late-term abortionist. Meanwhile, pro-lifers are allowed to present their defense to the jury, and no one familiar with pro-life trials expects that Scott Roeder will be allowed to present his defense to the jury either, which is that he prevented the murder of thousands of human beings with souls just like yours and mine who cry out to God as their bodies are mauled. If the accused isn't allowed to explain to the jury the only contested issue of the trial, how can you call it a trial by jury?